I was gonna say.
Good morning, everyone. Welcome to the January 19th meeting of the Montgomery County House Delegation. Today, we were scheduled to have a briefing by first with Congressman Glenn Ivey, but we just heard a little while ago from his office that he needs to reschedule for a good reason. So we will put him on a future agenda. Otherwise, we will move on with the three other items on our agenda for today. We have a work and voting session for the Land Use, Transportation, and Public Safety Committee. And then we'll have two briefings. First, continuing our discussion on bus rapid transit with the county, whose discussion we had to cut short at our meeting last week. And then we'll be joined with Montgomery County State's Attorney John McCarthy for a discussion with him. So we will proceed with our work and voting session for the Land Use, Transportation, and Public Safety Committee. Colleagues, you will note that there are three bills listed on the agenda. I will say that the first one, MC 6-24, school bus monitoring cameras, distribution of fines from Delegate Moon, we're going to hold. There was an amendment that was adopted conceptually in committee earlier this week on that bill. That amendment just came in late yesterday. And there was a request to review the text of that amendment in committee. So we're going to hold off on that bill in full delegation today, but I will turn it over to Chair Love to proceed with the other two bills.
Thank you, Madam Chair, and good morning, everyone. Good to see you this beautiful snowy Friday morning. We are going to start with MC 1024. This bill repeals a requirement under Section 21803A4 of the Transportation Article that Montgomery County or a municipality in Montgomery County perform an engineering and traffic investigation before decreasing the maximum speed limit on a highway in the jurisdiction. The committee adopted one amendment that repeals a prohibition in Montgomery County against the implementation of a new speed monitoring system on a portion of a highway in which the local authority has reduced the speed limit. And instead, we allow the local authority to put in a speed camera not earlier than 1 year after the speed camera has been lowered. So that's the summary, but let me give you a little bit of background to this. In 2021, this delegation enabled Montgomery County and local municipalities to reduce speed limits with two restrictions. One was they had to do a traffic and engineering study, and two was they could not put speed cameras on those highways where they had reduced the speed limit, and that was to avoid speed traps. So they dropped the speed limit, they put in a speed camera, and people got nailed unknowingly. In 2022, we allowed Baltimore City to raise and lower their speed limits without a traffic and engineering study because they had their complete streets plan. Since we adopted our local jurisdiction bill in 2021, Montgomery County has adopted Vision Zero plan, pedestrian safety, safe streets. They've done a whole lot of work. So the committee felt that it was appropriate to grant them the same authority that we had given, we being the full House, had given Baltimore City in 2022. So that was the bill as it came in. We also heard a proposed amendment that would change that whole speed camera, speed trap issue. And we said, okay, we don't think it's right to ban speed cameras forever on those areas that have had reduced speed limits, but we do think it's appropriate to set a limit and say, we still don't want those speed traps, so you can put in speed cameras a year after, at least a year after the speed limits have been lowered. So that's the explanation for the bill. Because there is an amendment, I will move the amendment. That's that 1 year prohibition on speed cameras. So, Madam Chair, I move the amendment.
Second. Oh, okay, David got it.
Moved by Chair Love, seconded by Delegate Moon. Is there questions or discussion on the amendment? Okay, seeing none. All those in favor of the amendment, please say aye or raise your hand.
Aye.
Anyone opposed? Any abstentions? Okay, the amendment passes unanimously.
Thank you, Madam Chair. I move the bill as amended.
Second.
Moved by Chair Love, seconded by Delegate Wilkins. Any discussion on the bill as amended? Okay, all those in favor, please say aye or raise your hand.
Aye.
Aye.
Anyone opposed or abstaining? Okay, MC 1024 passes unanimously as amended.
Thank you, Madam Chair. Our next bill is MC 1524. This bill authorizes Montgomery County to place and use speed monitoring systems on highways in Montgomery County identified as high risk for motor vehicle crashes that result in serious bodily injury or death by the county's most recent local strategic highway safety plan. Excess fines are allocated to finance safety projects at high-risk roadways or intersections identified in the latest safety plan, and on or before October 1, 2025, and every 5 years thereafter, the Montgomery County Department of Transportation, working with the Montgomery County Police Department, must evaluate how well each speed camera placed in accordance with the bill is working, and whether it reduces the speed of 85% of the drivers at this location. Move the bill, Madam Chair.
Second, Madam Chair.
And Chair Love, did this bill have an amendment?
No.
I thought that this one did have an amendment.
I believe it did, Madam Chair. We made some amending language to conform the bill that municipalities could use it.
Oh, you're absolutely right. I'm looking at an old bill summary. I'm so sorry. You are absolutely right. We did. Thank you, Madam Chair, and thank you, Bill sponsor, and apologies. Apparently the chair of the committee has no brain this morning.
No worries at all.
Move the amendment.
Okay, so the amendment's moved by Delegate Moon. Is there a second?
Second.
Seconded by Delegate Kaufman. Discussion on the amendment. Okay, all those in favor of the amendment, which adds municipalities, say aye or raise your hand.
Aye.
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 Anyone opposed or abstaining? Okay, the amendment passes unanimously.
Move the bill as amended.
Bill is moved by Chair Love, seconded by Delegate Moon. Any discussion on the bill as amended? All those in favor say aye or raise your hand.
Aye.
Aye.
Anyone
Aye.
opposed or abstaining? Okay, MC 1524 passes unanimously as amended. Thank you, Chair Love and the committee for your work on that. Colleagues, I will note that if you are the sponsor of any of these bills, our delegation does take care of getting the blueback requested. And so the 3 bills, I believe it was 3 that we passed last week, were introduced in the House earlier this week. Because they are listed as being sponsored by the Montgomery County delegation, they may not pop up on the alerts that your staff have set up, but Ralph is keeping an eye on those, and we will let you know when the hearings get scheduled for your bills, because preferably we will have bill sponsors presenting those bills when they get to the standing committees in the House. So just stay tuned as we've done in prior years for notifications about that and logistics for the hearings in the standing committees. So that concludes our work session and voting session for today, and we are plugging along very nicely here this morning in terms of time. So we'll move to our third agenda item, where we're going to continue our briefing from the county. Let's see, is Director Conklin already on the call this morning? I'm not sure that he's joined us yet. See that Sarah Morningstar is on the call. Sarah, do you have an estimate in terms of, or have you been in contact with the director this morning in terms of our briefing today?
I also know that Melanie is on the call. I have not. Melanie, do you know?
Yes, we thought the briefing was going to start about 9. We thought Congressman Ivey was going first, but let me reach out to them right now.
Well, and I think maybe since the state's attorney is on the call, we could move to the discussion with him and we could come back to BRT if that's all right with you all.
That would be great. Thank you.
Great. Okay, we will proceed to Montgomery County State's Attorney John McCarthy. And we'll give him a moment to come back on because I also told him not to expect to be on until much later in our meeting. We are moving along very well this morning.
just be one moment.
No worries. Thank you. And I'll say maybe while we're waiting, we can take committee announcements. Do any committee chairs have any future meetings that they would like to flag to their members? Chair Love.
Thank you, Madam Chair. Land Use, Transportation and Public Safety will, as usual, be meeting Monday at noon. Thanks.
Chair Chi.
Thank you, Madam Chair. Good morning, everyone. The Economic Development Committee will have our second work session and hopefully voting session to finish our work for this session this Thursday. So look out for emails and links. Thank you. Oh, 9 o'clock. I'm sorry.
Thank you. Any other chairs have an announcement? Yes,
Madam
Ralph.
Chair, I don't see Chair Lopez here, but Metro Washington will be meeting Monday evening at 6 rather than 7 due to the WIP meeting.
Okay, thank you. And as usual, for members of the public, all of our meetings are posted on the delegation website, as well as the link to the live stream for those. And with that, I will turn it over to State's Attorney McCarthy. Welcome.
Good morning to everybody. I just want to thank Delegate Carr for allowing me to come in here to speak to you. Well, what I want to do is address some information, and most of my information is going to be very specific to Montgomery County, at least the numbers in particular, to kind of give you a look at what kinds of numbers we're looking at in terms of juvenile criminal matters in the county. I do anticipate that within the next few days, there will be a bill dropped addressing many of the issues that I'm going to talk about here today in both this House and in the Senate. I want to let you know also that I've invited the current head of my juvenile division, Carlotta Woodward. She's online listening to this, and my former head, George Sims, who heads my team as community outreach. They're listening in, and if there is any questions that come up during the course of this presentation, they would be available to answer your questions as well. I will not be addressing the Juvenile Interrogation Act, and I will not be addressing car searches, because I don't think either of those things are going to be part of the bills that are going to be submitted next week. But I want to just share some information with you. First thing is, like, are there real declines? I think there is some conversation that goes on around the state, and I have had conversations with delegates and senators about the issue of what's going on in the area of juvenile justice, and they are confused because there are statements made, and I think they're made by Mr. Schroeder, that juvenile crime or arrests are actually down. And I would say that in terms of are there really declines in crime, I would say no. Looking at these numbers, this is a comparison. By the way, all of the numbers I am citing and have on my chart are from the Montgomery County Police Department. These are not internal numbers to my office. They are the numbers of the police department, and they reflect the juvenile crime. Now, I guess it's one of these issues. Can two things actually be true at the same time? Let me say to you, have there been declines in certain types of crimes in Montgomery County over a 3 or 4 year period of time? Well, the answer, you can see here that larceny is down from arrests from 387 to 128. Vandalism is down 48 to 8. CDS events are down from 344 to 33. Look, I am telling you, I think all of those things are still occurring. Why are those numbers down? They're down because Montgomery County Police is down 300 officers. They're down because look, if you go out there, and I would ask you, when you were in conversations with police officers and people enforcing laws against juveniles in the community, why aren't the arrests for those types of crimes occurring? They'll tell you they have a lot of frustration with the revolving door at DJS, and actually just don't want to get involved in those minor matters. And quite candidly, because of the focus on violent crime, they really don't have the time or the resources to get involved in some of those other matters. Now, what does the county, what does the community care about? These are your numbers. These are your community numbers about, I guess, what I would call violent crime. carjackings are up 85% year over year from 22 to 23. Just to give you an idea of in terms of arrests, in 2019, we arrested a grand total of 2 juveniles for carjacking in Montgomery County. That number in 2022, and I don't have the 23 numbers, was up to 30. And carjacking has gone up again, almost 100% in 2023 over 22. Gun violence offenses are up 220% year over year based on arrests in Montgomery County. Motor vehicle thefts, look, I can't imagine that there's anybody listening to me here today that it hasn't had people talking to them about the issues of increasing motor vehicle thefts. In 2019, there were 48 vehicle thefts where juveniles were arrested. In 2023, as of September of 2023, which are the most recent numbers we can get, 48 went to 360. You can see here motor vehicle thefts are up 200% over one single year. Individual shot, the difference between since 2019 to last year's numbers, the increase was 230%. Injuries with minor assaults from weapons or stabbings are up 100% from since 2019. These are, I think, these are staggering numbers. One of the things about these particular crimes, these are the crimes that destabilize and put fear into the hearts of our citizens. The other crimes, the vandalisms, the larcenies, the shopliftings, look, I don't think those things have stopped. I don't think that drug usage by young people has stopped. It's hard to walk around Montgomery County and not smell drugs in the air almost anywhere you go. And I was in favor of the decriminalization. But I'm telling you, the emphasis is on these major crimes. And so if we get it up the numbers in those misdemeanor kinds of offenses, is there a decline in arrests? Yes. But the level of seriousness and what is causing, I guess, a lot of concern in our community is in these violent crime areas. And this level of crime is exploding. Look, a state that I wish I could come in here and tell you that they didn't go up. And there were long periods of time, I guess the first 13 or 14 years I was here, when Ike was county exec and Tom was, our crime rate went down 29% over a 13-year period of time. And it was down in every police district. So these numbers have reversed themselves very dramatically since 2019.
Mr. McCarthy, if you could maybe lean a little closer to your computer, I'm hearing from a few members that we're having a little bit of more difficulty hearing you suddenly.
Okay. Can you hear me now? Is that better?
It's better. It's still on the quiet side. I'm not sure what happened here in terms of the technology.
Okay.
Madam Chair, is there a piece of paper over his microphone, perhaps?
I don't think so. Let me. I apologize. Let me just say, I'll try to say this much louder. I hope that this is happening. Is that better?
Yes, you're much clearer now.
Okay. Among the legislative changes that we are requesting are to give authority for the state's attorney's office to review all felonies and firearm charges involving juveniles. We used to have that authority before. The changes that came about in the last couple of years took it such that we are only notified by DJS when a person is arrested if it is a crime of violence, and they are mandated then to include us, but not for felonies. Well, what kinds of felonies might we not now learn about? Well, auto theft. To give you one anecdote, and Carlotta Woodward is here with me. We have had cases here where individuals have gone out, they have stolen 4, 5, 6 cars. We never knew about it. We never knew about it. Then a child is referred to us maybe on the 6th or 7th car they stole. And we never knew about the earlier cases were held at intake. We previously, prior to the changes that took place in the law before, had the authority to review all felonies and all firearm charges. We were asking for that to be back again so that we can look at that. There's a lot of things. distribution of drugs, some possession. Some of these cases we don't see anymore as we once did because they're not crimes of violence. The length of probation, one of the other issues that we think needs to be changed. The length of probation is generally limited to 6 months. It can be extended by permission of the court, sometimes in increments of 3 months, up to, for felonies up to 2 years, but for misdemeanors, 1 year. The court should have the authority to set the appropriate period of probation. What this bill does is I understand the spirit of the bill, but what it doesn't do is it doesn't give any faith to the men and women who are the judges in Montgomery County that are in court. They see the child, they see the parents, they see the defense attorney, they see the prosecutor, and they may look at that child. Maybe they have an addiction to an opiate. Well, I know based on social science research and our efforts to try to deal with people who have opiate addictions in our community, that opiate treatments, to be successful, have to be 18 months, maybe 2 years, because the first 6 months you're in these programs, your brain is not wired yet, free of the opiate, to allow the rehabilitation effort to take place. I really think artificial limitations on probation really comment indirectly on your judges, not even your prosecutors, because the judges are the ones that are setting this up. And I firmly believe the men and women in my county, whether it's a Kathleen DeMay or it's a Carla Smith, that's who's in juvenile court. I think they should be free to fashion a sentence with more information than a hard and fast rule that says 6 months for everybody. All right. Or you have to go petition it back, and you're setting these kids up for failure when you limit the probation. I think the people that I'm speaking to today know this. When it comes to juvenile matters, the vast majority of them never come to my office. The vast majority never comes to my office. 70% of all juvenile matters go to the Department of Juvenile Services, DJS, stop there. And if it stops there, we, in many instances, know nothing about it, like the auto theft example that I gave you before. Again, we need to take that artificial limitation on it. Why is that 6-month artificial limitation problematic? Well, here's why it's problematic. If you took every single slot that's available in the juvenile justice system for the placement of a child, and again, the purpose is to rehabilitate, help that child, and get them reintegrated with their family as soon as possible. But there's 793 spots. That's what that number is. Judges in this state committed or recommended close to 1,600 kids for treatment last year. 1,600 doesn't go into 793 very well. What's the effect in your community? And again, I have Carlotta Woodward here, who's in court every day on these matters. We very often see delays in getting placement for these kids for 3 or 4 months. There is simply no room in the inn for the type of treatment that child needs. And if you look at the numbers that are published by DJS, the average length of time that somebody receives treatment through anybody who is placed or goes into treatment is about 5 months. Now, I ask you to pause for a second. Do we really believe that 5 months is adequate length of time to deal with a child who has the constellation of issues that we sometimes see in our court? And I would also just mention here, just parenthetically, because Carlotta and I were talking about this earlier today, is that sometimes the kids who come in on the misdemeanor matters, not the felonies, have the most profound and complicated set of circumstances that we're dealing with. Whether it's a felony or misdemeanor doesn't really give us any idea of what we're really dealing with that particular child. Delays in making decisions. Look, one of the things by not giving us notification, DJS should be required in all crimes to give us notification, particularly felonies. They have 25 days for them to make a decision about whether they're going to paper a case or charge a case. Well, in a serious felony case, that 25-day delay is 25 days already built into it before they make a decision on the cases they actually send to us. So there is a real issue about how much time should they have to make this decision. It's a delay for the child getting treatment. It's a delay for us being notified that the case even exists. And therefore, it delays our coordination with the police department about investigating the case. And if it is a serious matter, let's say video camera footage at your typical CVS, where lots of violent crimes have sadly occurred. Well, those things are usually on loops. And maybe the loop is 48 hours. Maybe it's a week long. Maybe it's 10 days long, and they cover over your video. That 25-day delay will ultimately compromise our ability to prosecute that case. And I know many of you know this, but just as we live in an epidemic where many of our young people are challenged by opiate addictions, we have since 2019 had no residential drug treatment facility for juveniles in this state. I think the name of the place was Mountain Manor, but it was closed and it doesn't exist. So when we are looking at this issue and whatever issue we're talking about, I would ask you to take into consideration the Montgomery County numbers and some of the practical difficulties of getting children into treatment, and some of the ways in which, like, an artificial limit of 6 months has hampered judges who I think have absolutely the best interests of the kids in heart. And if they thought it should be longer, they should have the authority to do that. They have far more information than a bumper sticker 6 months. Look, another thing that happens with young people that are convicted of misdemeanors, all right? One of the new laws that was passed said, if you have a technical violation of probation for a misdemeanor, you cannot be detained. You can never be locked. You never can be removed from the community. Well, let me define, what is a technical violation of probation? A technical violation is failing to report to your probation officer, failing your drug test, failing to attend mental health, blowing off drug counseling. We now have a new phenomena that is occurring because of this. In part, kids just don't honor their conditions of probation. They blow it off. And the period of probation is shorter, artificially at 6 months. And what can a judge do to encourage the child to attend the counseling, to get into the treatment that they so desperately need? I will say they don't have the ability.
And I'm just waiting.
I'm sorry, if everyone can make sure that they are muted besides Mr. McCarthy.
One of the things that has been suggested is two things. Number one, expanding the definition of technical violations, but one of the other proposals is to create graduated sanctions for technical violations by a child who's on probation. Maybe the first time the child could be placed on community detention where they stay home, but they would be under restricted hours and things like that. And then subsequent and all second and all subsequent technical violations would give the court, not the prosecutor, not the defense attorney, but give the court the discretion to commit or detain the child if it was necessary to get the child the treatment that they needed. And right now they cannot do that for technical violations. I'd also say there is a difference between detain and commit. Detain is something you do pre-trial. Detain is pre-trial. Commit is after adjudication. All right. The court should have the authority to detain or commit the juvenile who commit to misdemeanors under circumstances where such action is required to ensure the safety of the child or the community. Whether that's, and again, I believe that that's going to be addressed in the bill that you may see dropped next week. And for some of the reasons I've already articulated, that's why we're there. We also would say to you, there are now limitations below the age of 12, and maybe I'll go to the final one that's on this list. Expand crimes for which children over the age of 10 can be charged. Threats of mass destruction, false fire alarms. Several of you have discussed with me over at the end of last year, actually just a couple of months ago, we had a 12-year-old boy who shut down instruction at multiple of our high schools and other schools by calling in threats of mass destruction, false fire alarms. And I don't know the absolute dollar figure that was spent by the bomb squad and the fire department and the police responses, but a number of our high schools, and I think one of our high schools was shut down twice or three times within a 2-week period of time. Again, so expanding certain types of crimes that we can look at. Possession with intent to distribute. Everything but, I'm not talking about marijuana, but possession with intent to distribute drugs, particularly fentanyl in our schools. I'm sure that you know the very sad numbers that last year, 11 students that were in Montgomery County Public School lost their lives to fentanyl overdoses. Another 26 overdosed. I don't have the numbers for this particular year, but addiction, and I am also told that particularly in the Hispanic community, the influence of addiction and the influence of opiates has absolutely blown up in that community. And sex offenses, I literally got a phone call from somebody that is listening to me right now yesterday about a sex offense on a girl in a grammar school in Montgomery County yesterday, because a constituent called them and a young girl was sexually assaulted in a grammar school by another individual. So sexual assaults, distribution of drugs, threats of mass violence, and handgun offenses. Those are kinds of crimes that we would be asking you to consider expanding that limited category where it can go down to 10 years old. I'm willing to take questions on the presentation I just made, or invite, you can direct your questions to Carlotta or to George to answer if you would like. But I think as we approach this issue, my objective as state's attorney, it's about public safety. When I go out, it is the carjackings, it is the robberies. I do not believe, I almost, it is completely misleading to say that juvenile crime has declined over since 2019 to today. I think the misdemeanor offenses that make the numbers less than they were are not because it's not happening. Does anybody here really think that those crimes are not happening? I think the arrests are not happening for some of the reasons I already articulated, but I think we have a huge challenge in some of these areas. But and again, I have not talked about interrogation. I've not talked about car thefts, and we had car searches, and there has been a decline in guns that have been removed from cars this past year since that went into effect.
Thank you. Yeah, thank you, State's Attorney McCarthy. There has been a request. Would it be possible for your office to share the PowerPoint slides with our administrator, Ralph, so that we can distribute those to the delegation?
The answer is absolutely yes, and I will do that. I will absolutely do that. Yes.
Perfect. Okay, so we have some hands up for questions. Colleagues, if you have questions, please use the virtual raise hand function to get into the queue. We'll start with Delegate Foley.
Oh, thank you, Madam Chair. Thank you, State's Attorney McCarthy, for this presentation and for taking the time to brief us on this. I know we're all concerned about public safety, and so I really appreciate your being here. I have a couple questions about your presentation, and then I have one other question, if I could, Madam Chair. So my question about your presentation is the first slide that you put up, where you listed, maybe if you could, or actually it's the third slide, if you could maybe post that so that I can see it.
Is that about the violent crime or the non-violent crime?
I think it's the nonviolent crime.
Okay,
Yeah.
all right,
Okay.
sure.
Yeah, the third one. Yeah. If you could put that up.
That one there?
Yeah, yeah. So my question is, what constitutes larceny? I'm just not a criminal justice expert.
A larceny, thank you, that's a great question. Larceny is a theft, I guess. What might get grouped into the larcenies are shoplifting. That might be, it could be shoplifting. It could be it could be somebody who stole a computer, somebody stole your wallet, somebody stole your cell phone. Those are the kinds of objects and the kinds of cases where we see kids getting involved. They go into a grocery store and, where we've had, I can't go to a grocery store in Montgomery County where there's not a security guard at the grocery store.
Right.
Because of the thefts that are occurring in the grocery stores.
Yeah. Okay. Thank you for that. And so my question on larceny is, so that does or does not include nonviolent carjackings?
That does not. That's a separate category.
Okay. Thank you. All right. And then you had another slide later in your presentation about the violent crime. Can I see that?
There you go.
Okay, there, and carjacking is on that. Okay, let me ask you, so this slide reflects just juvenile crime, is that correct?
Yes, this is specifically the numbers I got from Montgomery County where they have closed juvenile. Look, not every case gets closed, all right?
Right.
So saying to you, whatever the number of like for instance, car thefts, I think like 700 or 800 car thefts last year. I mean, the number is much higher. These are the instances where closures are made and the percentages of cases where that theft was linked to a juvenile.
Okay, thank you for that. And what I would like to see, and you can give this to me offline or give it to us offline, is a breakdown like this of all crimes, not just juvenile crimes. So like crimes committed by adults as well. That would be good for us for context, if you don't mind.
I'd be happy to get that. I will tell you, my source will be the police department, and I will go to, I will ask them for those numbers and share them with you.
Okay, fine. Thank you so much. And then my final question is about the legislation, as I understand it, as you were presenting what was in the legislation. If I heard and saw correctly, you said that the legislation would allow to detain or commit juveniles, discretionary power to detain or commit juveniles pre-adjudication. And so are you talking about like without bail? I mean, just so that if there was a juvenile and the court decided to commit them, that they could commit them to incarceration or to confinement until a trial without bail, like a remand, or
with your permission, I'm going to ask Carlotta Woodward, who is currently the head of my juvenile division. Carlotta, can you unmute yourself and speak to?
Yes. No, what would end up happening is when a child is charged with an offense or arrested, the Department of Juvenile Services is the one that makes the determination if a child is going to be detained or not detained. If they determine a child is going to be detained, and that includes being detained in a facility, and it also includes being placed on a home electronic monitoring, they are required to have what's called an emergency hearing before a judge. And that is done in the next business day. So when you're asking if there's, being detained without the ability to see a judge, they do see a judge within 24 hours. The judge then makes the determination if they will remain detained, remain on community detention, or if they will be released without any type of detention. And if a child is detained, it is mandated under the law that they have a hearing every 14 days. So you would have the emergency hearing, and then if they are detained, either in a facility, detention facility, or on community detention, they are required by law every 14 days to see a judge to review the detention status of that child.
Okay, thank you. And just as a small follow-up, so the pre-adjudication that was referred to, the period of pre-adjudication that was referred to in the slide, that means prior to the emergency hearing? Is that what you're, no?
No. So pre-adjudication. So if a child is detained, either community detention or detention, adjudication is trial. So if a child is detained, we are required to try that case within 30 days. But the emergency hearing happens within the next business day, usually within 24 hours of being detained. And then they have a hearing every 14 days up until the adjudicatory hearing. So it's 30 days. So typically you're thinking that they have it, day 1, day 14, day 28, if it goes to 30 days, or if we're able to try it within 28 days.
Okay.
So there's always a finger on the pulse of the child, that the child has to be seen by a judge in the courtroom to review that detention status.
Okay, but we're talking about the law is talking about expanding crimes for children under 10 years of age. So we could conceivably have a 10-year-old detained for 14 days?
Not under 10, ma'am. It's
No, 10. I said 10, 11, 12. Right?
Potentially.
Okay, thank you.
Delegate Fraser Hidalgo.
Thank you. So I have just a couple of questions. Number one, it was stated, Mr. McCarthy, you had stated that in some cases you're not referred to auto thefts until the 6th or 7th time. Is that what you stated?
The answer, Delegate Hidalgo, the answer is yes. And I would also indicate
So
that.
how many?
Okay,
so how many times, if that's the number of times that they've been caught and juvenile services has become involved, and then you find out about it after the 6th or 7th time, how many times do you think they actually stole cars and were not caught for the theft of those cars?
That's a number I would be pure speculation on my part, but I
understand, but you've been our state's attorney for a number of years. You have a lot of experience.
Let me tell you, if we caught him 6 or 7 times, we don't bat 1,000 making these arrests. So I am sure that there are other cars that were also taken. Based on the experience, I would assume that there are multiple other cars that they've also taken for which they were not apprehended.
So it wouldn't surprise you if you found out that they had stolen 20 or 30 or 40 cars before they got caught.
Again, I think that's possible. Again, I understand exactly where you're coming from, and I think we to some extent assume that that's the case, but right. The actual number I'd be guessing at.
Okay, and then thank you. And then the second part of this, the second part of my question really has to do with my personal experience as a father that have kids in Montgomery County Public Schools. So I'm curious as to how violent crime is reviewed or referred. And I will tell you that the reason I bring this up is because there are a lot of victims all over the board on all of this stuff, right? There's the victims of the juveniles, of the kids that have issues and commit these crimes and how they got to where they are, and making sure that they get the help they need to ensure they don't commit future crimes. And then there's the victims of the crimes that they've committed. And I have video, my kids bring home video, they get sent video all the time of fighting in Montgomery County Public Schools. And these are felonies. I mean, I have video of kids being knocked unconscious, their heads being driven into the concrete, and them having seizures. And when I think about, victims, and I think about what that means to them, I wonder, okay, so the kid that did this, again, I have video of it. The kid that did this was suspended for 3 days and was back in school again. And I watched from 4 or 5 angles, because this is what kids do. The other part of the victimization here is that a lot of kids seem to think it's really cool and fun to video these fights. And so now we have a whole generation of kids that instead of trying to get involved, to try to separate people, to do what they can to tamp down the fighting and the violence, seem to think it's really, really cool to just yell, fight, 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 video it, post it on Instagram for everybody to see, create fight club channels at our schools. And the kid that does this is like, okay, well, I'll be back at school in 2 or 3 days. There's no real repercussions. So I am very, very concerned when I see this. And I'm very concerned with what the relation with Montgomery County Public Schools is and why these kids aren't being charged. Because that student may end up having a traumatic brain injury that follows them with seizures for the rest of their lives because they sat in the wrong lunch room seat. They're in the cafeteria eating lunch. One kid comes up and says, "That's my seat," and then proceeds to beat the other kid to a point of seizures on the floor. And I don't understand, the pendulum on this goes back and forth over the years, and the pendulum is just in a really, really bad place right now. So I'm curious if you could tell me how you work with the public schools on these particular issues, because they're very, very disturbing.
May I say that there is a memorandum of understanding that is signed off. I signed off on it. The school system signs off on it, and the police sign off on it. That memorandum of understanding is principally between the schools and the police about kind of delineating who's going to take the lead on events that occur on school property that is of a criminal nature, who takes the lead, who does the investigation, and things like that. So that does exist. I would also indicate to you, last year, maybe completely consistent with your question, I was called by members of the school board because that within certain middle schools where the kids were under the age of 12, there were lots of fights going on, and they were begging for our help in trying to help us deal with fight issues that were occurring in schools in Montgomery County. But because of some of the changes that took place, those second-degree assaults that were occurring, the fights that were occurring, disrupting schools, we had no role to play in that anymore. It was no longer a delinquent act over which we had jurisdiction. And so I will tell you, I heard some of this frustration came bubbling up to me from teachers and school board members that were begging me for help because of issues that they were describing as violence in the schools that involve fights that we no longer had any authority to get involved in. By the way, I should say this, and I think everybody knows this, when it comes to juvenile justice, the state's attorney's office even has historically only seen about 30% of the cases. About 70% of the cases are held at intake and are informally adjusted by the Department of Juvenile Services. What is referred to us, and even if a case is referred to it, we don't necessarily paper those cases. We still then have to review them. So, Carlotta, do you want to speak? If I could invite Carlotta to come in here again, could you speak to Delegate Fraser Hidalgo's comment there about our relationship with the schools and where we fit into that?
I mean, so just as a back history is that the only way that our office can receive cases is through the Department of Juvenile Services. So if you as a parent were to come into our office, which I have weekly, parents coming in asking for help, their child is a victim, they want charges against their own child because of what's going on. The law does not permit our office to initiate any type of charging against juveniles. It has to go through the Department of Juvenile Services. And how that happens is either the police will then charge a child and then that is forwarded to the Department of Juvenile Services, or there is an ability for citizens like we do in the adult system, which is a citizen's complaint, where you can go to the Department of Juvenile Services as a citizen and ask for charges to be placed against a particular child. It is then up to the department to then forward those particular cases to us. And if they don't forward them, there's nothing that we can do. We can't ask them to forward them. We can't force them to forward those cases. So there's nothing that we can do unless they authorize them. When it comes with the schools and the things that you are talking about, because we do see it, is the second degree assault component is a misdemeanor, and we only have first degree assault, which is a felony, and you have the second degree assault. to get to a first degree assault is very significant. It has to be a specific intent crime with the intent to commit serious bodily injury and or resulting in death. So to get to a first degree assault is a really high hurdle. So most of the assaults that we see that happen in schools are second degree assaults. And we have, you know, varying degrees of a second degree assault where you talked about kind of examples, which could be potentially a very bad second degree assault. With respect to that, that's a misdemeanor. And so we have no authority over that. Children under the age of 13 cannot be charged with second degree assaults, period. And it really falls on the schools if they want a child to be charged. And that would be then them calling the police for help with respect to that. So it falls on the schools to then notify the police, or if somebody at the school wants to file a citizen's complaint, to have charges initiated through the Department of Juvenile Services. So that's kind of, you know, we can't force the schools to do anything, and it's got to be their decision as to how they're going to handle what's going on in their schools, whether it's going to rise to the level that's going to get to a point where it would even be referred to the Department of Juvenile Services. I don't know if that answers your question, but that's kind of, you know, what we're seeing.
Yeah, I mean, it does to a degree, and I'll follow up. I mean, I will tell you as a parent and as a product of Montgomery County Public Schools, what I'm seeing in the school system today is nothing like I've ever seen before. And I am speaking for a lot of parents in my district, the kids that my kids go to school with, and the normalization of this violence is disturbing because that normalization is going to follow them for the rest of their lives. And the victimization of those kids that this is happening to, that will follow them for the rest of their lives. That bullying behavior, when we see this bullying behavior and people wonder why we have school shootings and other things, because people were bullied. This is why. This is why. And this is very, very scary to me. I have video. I will send it to you. But he intentionally took his knee and drove it into this kid's head off of the concrete. It is extraordinarily disturbing. And 2 days later, that kid was right back in school. I'll send you the video. And please keep in touch if there's anything that I can do to help with these. I think that it's time. Thank you.
Delegate Moon.
Excuse me. Thank you, Madam Chair. I have a couple questions, and I just want to start with one basic question on the data that's up on the screen, actually. And it relates to this. I've seen in a lot of these discussions and presentations, and thank you, it's very detailed, and a lot of what you're suggesting has been under discussion, obviously, by the Judiciary and Judicial Proceedings Committees over the interim. So stay tuned for more on that. But just at least with respect to the data, I do keep seeing carjacking and car theft commingled and discussions of youth violence coming up. So I'm just curious if you have the absolute raw numbers for the data we're seeing on the screen right now, like how many carjackings exactly are we talking? I think you said the motor vehicle thefts were into the 700 or something like that. But carjackings, is that like 1 or is it 100? You know, I'm actually curious what the scale of problem is. Colleagues that were a 1 million person county.
Yeah, let me say, Delegate Moon, I do have copies of all the numbers. I'm looking at one sheet right now, just for example. And again, I understand you want a hard number, but for instance, motor vehicle theft in 2019, there were 48. In 2020, there was 41. The next year was 58. Next year was 80. The next year it was 141. And the final year was 368. So I can give you a longitude. It just seems.
Yeah, no, that makes sense. Carjacking is the one I'm actually more curious about because that one catches a lot of headlines.
It does, and I know I have those numbers, and I can get them. And again, my source for the number will not be internal from my office. I will get Delegate Moon. I will get them for you, and my source will be Montgomery County Police.
Got it. And I guess the only reason I ask is if we were starting with 1 or 2 or something like that, and we had 3 or 4, that's 100 or 200% increase on a small number. Very serious, obviously, but again, in terms of likelihood of encountering X or Y behavior, I personally had my car stolen by 13-year-olds in multiple car theft. They were caught by the county police and put into supervision actually by your office. It was multiple kids. They were 13-year-olds from my neighborhood. One of them to this day continues to be in detention. And the other, I believe, is no longer supervised, just to give you a window into how this played out. So it's not exactly a new story, but if you could get back on the raw numbers of the carjackings, I would actually be very curious to send that background to colleagues. The second question I have, if you don't mind me pivoting for a second, since we have you here, there was a Court of Appeals case this interim where I believe the bottom line was some of the expungement laws we have passed are being interpreted in a way that the state's attorneys can object to the expungement if there was a technical parole violation. And so, theoretically, they missed a meeting or something like that. One could say, oh, no, you're not eligible for expungement. You didn't complete your sentence because of that technical parole violation. And seemingly there's nothing they can do about that now. So I've been trying to understand, because other states' attorneys seemingly weren't objecting on that basis, but the Montgomery County office was, and that issue went all the way up to the Court of Appeal, the Maryland Supreme Court. And so now I know it's going to be the subject of legislation this session. If you could provide, I guess, some explanation of what was going on there, what was the nature of these objections? Because what I'm understanding is they were technical objections were the subject of the court ruling. And it doesn't seem like other counties did that. And it doesn't seem like that was the spirit in which the assembly was moving these expungement laws. I'd be curious if you could articulate, I guess, what the Montgomery County policy was on objecting to these expungements.
Let me say, I begin by saying I don't think there was any policy that was the Montgomery County policy objecting to these. So can I say to you, I am unfamiliar with the issue that you're talking about. All right. So I made no policy decision relative to this. We are inundated with hundreds of petitions for expungements every week in the office. We handle about 25,000 criminal matters a year in this office, and and several hundred expungement petitions come in. Let me say monthly. The expungement petitions, we train some paralegals. It's not a policy decision that's been made or changed as a result of the legislation. We have paralegals that are trained to follow the law as it is written. So I think that what they do is they literally just look at the statute, and if it qualifies, which it does in 99% of the cases, they approve it. If it doesn't, if they haven't waited long enough since they've been off for probation, or sometimes there are time limitations, they just go strictly by what the statute says, and that's what they're trained to do. They're trained to follow the law as it is written. There is no separate and independent policy in my office on this issue, separate from saying follow what the statute is. Because we've never, to be very honest with Delegate, we've never discussed this issue. They're just trained to, here's the law, follow the law.
All right. Well, thank you for that answer. It appears the policy was different in other states' attorneys' offices, and their paralegals were trained differently. But I'll leave that there. Thank you.
Delegate Kaufman.
Thank you. It took me a minute to get off mute, but can you hear me now?
Yes.
Thank you, Mr. McCarthy. I think your presentation was very interesting. And I certainly understand your desire for more tools. But Delegate Crutchfield can correct me if I'm wrong, but I believe the number of sinus petitions that were filed by police were in the single digits. So in the Montgomery County, a county of 1.1 million people. So I'm just curious why you think we should give law enforcement more tools when police are not using an existing tool that gets the kid assistance but is slightly less draconian. The other thing is I understand your frustration with the young man that kept calling in all those bomb threats and things like that. But I think I'm very proud that my predecessors, before I got elected, passed an anti-swatting piece of legislation that could have benefited you in those cases. So I know we want to get to Director Coughlin, but thank you very much for taking my questions, and I look forward to your answers.
Delegate Kaufman, I actually appreciate very much your bringing up the issue of SINs. Let me say, and again, Ms. Woodward and I have spoken.
That's child in need of assistance for non-judiciary committee members.
SINs is a child in need of supervision, and quite candidly, I asked Carlotta this. We've talked about this. I am unfamiliar with there ever having been filed by DJS I've only been here 40 years. I've never seen them file one of these petitions in 40 years. So ever in Montgomery County. I'm not familiar with them having done that. I will tell you, in the vast majority of jurisdictions don't use them. And if they do in fact use them, SINs petitions have typically been used in two types of cases. One, to address the issue of delinquency for a child who's failing to attend school. Or number two, they've generally become ungovernable by their parents in the community. So when they've been used before, it's involved in those situations. SINs petitions, and the SINs is not a delinquent act. It's not something over which the state's attorney's office doesn't prosecute or handle. Well, we don't initiate these issues. And I would also say to you, one of the issues of SINs that I think could be potentially problematic is the same thing we're having when you set up a system where a child violates probation. Technically, they're not showing up. They're not going to drug treatment. That's a technical violation. A non-technical violation would be you committed a new crime or you completely absconded from probation and moved away. We don't even know where you are. Those are non-technical, but they're very few. Almost anything a child can do that violates their probation is going to be technical. If without the power to detain, you have no teeth in it, I will tell you a SINs petition is voluntary. It's voluntary. If people choose to blow it off, not adhere, if the child who is ungovernable, not going to school, or fits into any one of those categories, what teeth does the court have to compel the child to change their behavior? And I would suggest, first of all, they're not widely used. I know this has become a discussion issue, but in the situations where they were used, they were not used to address crime. They were used to address delinquency, or just basically being a kid who didn't pay attention to anybody, that didn't always amount to a crime. That's a child in need of supervision. They're out of control. Now we're taking something that was used for a very limited purpose, that's not a delinquent act, that's not criminal, and you're bringing the court into that process.
Well, I thank you, and just very briefly, I thank you for the education, because I understand from talking to Mr. Gibson that SINs petitions on occasion can be mandatory. So I thank you for clarifying that they were voluntary.
Okay, thank you.
Delegate Miracle North.
Thank you, Madam Chair. And thank you, Ms. McCarthy, for your presentation, and to the office for joining us this morning. I want to circle back to the topic Delegate Foley and Delegate Moon had brought up regarding the larceny data, because that too was a little confusing for me. Larceny is the theft of personal property, so that would include auto theft. Isn't that correct?
The answer is yes, but I don't think they double count. All right. Delegate North, you are absolutely correct. Stealing a car is a form of larceny. but they put them in different categories. I don't think they double count.
Okay, I just wanted to make sure because the larceny numbers being down and yet all theft numbers going up, I wasn't clear on what that
Because
meant.
they put it in a, I guess they count the crime in its most serious category. You know, everything can be broken down into lesser included. Now, if you did a robbery, you count it as a robbery. Then you can count it as a theft. Then you can count it as an assault. You know, a robbery is a theft plus assault equals robbery. They don't triple count it. And I think I think that's what they do here. I don't think they double count.
And is it possible to get us data of repeat offenders? I do notice the increase in numbers, but how many of them are talking about the same person?
I'm sure. Carlotta, do you want to jump in there and how accessible is that?
I mean, I can speak, excuse me, I can speak to the police department with respect to that. It would have to be breaking down, because I think the numbers that we got are broken down by the actual offense when it comes to a repeat offender. I don't know how easy that is, but I can obviously try to figure it out and work with the police department on that. Our office, we can look at kind of each child individually, but it would be literally each child individually that would be coming into the system to make a determination about the repeat offenders. But I can absolutely look into that.
Okay, thank you. And just to clarify, what is considered a gun violation for those who aren't in the judiciary or criminal justice field?
Well, a gun could be, well, for anybody under the age of 21, by the way, possession of a handgun by an individual under the age of 21 is illegal. So it could be possession underage. It could be simple possession. It could be transporting a handgun in a motor vehicle. There are other more aggravated handgun offenses, like if you used a handgun in the commission of a crime of violence, like a robbery or a rape. So handgun violation, there are multiple types of handgun violations. I think that possession and use in the commission of a felony are probably the most typical two ways we see it. Carlotta, do you want to add anything on the handgun thing there?
Sure. I mean, you can also have, wear carry, which is where they're actually wearing. It could be loaded handgun versus unloaded handgun. And it can also be with drug trafficking offenses. So if you're using a firearm in a drug trafficking offense. So those are kind of, and the ones that Mr. McCarthy had said are the ones. But typically we see them with possession of a firearm under 21 or in a vehicle or in the use in a crime of violence or a felony.
Okay, thank you. And in terms of the point you made about seeing delays and I guess getting back from DJS, like what the juvenile is doing, you mentioned about waiting like up to 25 days. Is it possible to get a better sense of that? Because I can't imagine. Does everyone wait 25 days? I've done juvenile cases. I don't remember that length of time, but I know there it's not like the next day. So you could speak more on that particular situation.
I appreciate that question as well, and I'll invite Carlotta's comment at the back end of this. The 25 days is set by statute.
Right.
And currently DJS has 25 days. Once they receive a case, they have 25 days as to whether or not they're going to forward the case and recommend that it potentially be, they have 25 days to make a decision as whether they're going to hold it at intake, informally adjust it, or they're going to forward the case on for potential charging by the state's attorney's office. And they have 25 days to do that. And I guess I'm pointing out the 25 days. It's set by statute. I think there's clearly times when they report it to us sooner, but they have up to 25 days. And that does, particularly in the most serious crimes, cause some issues. Carlotta, do you want to make a comment about that?
Sure. So typically when the department receives a case, they have to do their data entry. They have to sign it to an intake officer who will then have to conduct what's called like an intake with the child and the child's parents. So it depending on how quickly that they can do that is when they then make the decision. Once they make the decision, if they are mandated by law to forward it to our office, or if they choose to forward it to our office, which is at their discretion in certain circumstances, our office will then receive it, and we have 30 days to review that case to make a determination as to whether we're going to formally charge or formally petition that particular case in court. And that 30 days is important to us because we actually have to look to see, do we have enough evidence to be able to prove it? Are we going to actually charge this kid formally in juvenile court? So there is a lag time. And I will tell you, we do sometimes get cases pretty quickly, but those are for the kids that are not detained. If a child is detained, it's immediate. So that's why, so if a child is detained and is charged with, I'll just use armed carjacking, it literally is 30 days from the date that child comes into court to the date of adjudication. So in a non-detained, I know this is a lot, but in a non-detained case, let's say the department waits 25 days, it's forwarded to our office, we then petition it within 30 days. That kid is probably not getting to adjudication for probably about 75 days. So that's the lag time from when a child is initially charged to the time that the child would actually be for adjudication pursuant to the statute. We have very, very, very strict timelines, but those are the timelines. I don't know if that's helpful to you, but that's kind of where the timelines work.
Right. Well, it's more just educating my colleagues because like I said, I've done juvenile cases. So I remember there are circumstances where DGS never heard from the juvenile or the family. So that 25 days does occur. If they don't hear from them, then the case gets forwarded. So those happen for a few, but it does happen. On the topic of not hearing from the juvenile, I noticed that you mentioned regarding technical violation of probation that sometimes the kids blow it off. What about the circumstances where they might not be able to get to the probation officer or get to where they're supposed to be because they're juveniles and maybe their parents are working or grandparents? Have you come across those circumstances?
Yes, we have, but we're not filing violations on those.
Okay,
so
great.
if I can explain, violations of probation are not mandated to happen immediately. So violations of probation are typically initiated by the Department of Juvenile Services. And it's usually, in fairness to say, as a last resort. So a lot of times we will see what we call a memo that comes from DJS to the court that says child A is supposed to be going to therapy, but is having issues with transportation. So then we may or may not have a hearing to try to facilitate how we can help the family in allowing the child to be compliant on probation. It does not result in a violation of probation. There are multiple chances that are given. A lot of times, as a prosecutor, I won't know that the child isn't going to therapy. DJS will be trying to work with that child prior to letting the court or the state know that there's a problem. So it's not automatic for violations of probation. It doesn't happen just on the first time because there's an issue. Listen, we understand that they're children. We understand that there's transportation issues. We also have dealt with issues where parents refuse to help the child because they would say, it's not my probation, it's his probation or her probation. So we do take into account that doesn't result in a violation of probation being mandated, if that's helpful to you.
Very much so. Thank you. And my last question is, how involved is the office with the restorative justice goals of MCPS and also not only MCPS, but talking to PTAs? I have a first grader and I hear stories of bullying, and, my inclination is I'm going to go talk to the parent at some point to deal with this issue, or the parents that are involved. But I never really hear, in terms of like my conversation with other parents, I've heard from State's Attorney's Office in this, or I've learned more about the juvenile justice in the county. So what's the relationship between MCPS and the PTA in terms of educating the public?
George, is George Sims there? George, are you there?
Yeah, yes, this is George Sims. I'm from the State's Attorney's Office. Can you hear me?
Yes.
Yeah, thank you. So, yes, our office goes to PTA meetings all the time. Last week, I was at the Herbert Hoover Middle School PTA meeting. A couple of weeks before that, or rather in December, I believe, Our office was twice at Kingsview Middle School PTA. Either November or December, we were at Tacoma Park Middle School PTA. We're at Baker Middle School, speaking to the entire student body, but we're extensively involved with PTA. What we talk to them about when we go to the PTA meetings are the very things we're talking about now, especially relating to cyber crimes, especially relating to bullying, in-person bullying, cyberbullying, the whole issue about taking videos of fights and in cases where that can actually be another form of bullying. So there's a lot that we're doing with that, especially in PTAs.
I would also say one of the things that I'm very proud of in the school year that just concluded, I appeared in every public high school in Montgomery County and talked to every high school student in Montgomery County about two issues. One had to do about the proliferation and the bringing of guns into our schools. I had talked to every single high school student in the community in conjunction with the school system, talking directly to the kids. I did the same thing when it came to the opiate epidemic when I joined with the Montgomery County schools superintendent, and I've been in every public high school personally myself. We have 26 high schools, by the way, so that was 52 appearances, and I've spoken to every single child about those issues. And that's on top of continuing things that we do, like the truancy prevention program for the school system, which is run by our office, which Mr. Sims could address. It also has to do with the Choose Respect program that addresses teen violence. And we also have an anti-bullying program that we widely make presentations on consistently with PTAs, because parents are very concerned about this, but so are kids. We have a variety of different programs. They're ongoing, they're consistent, and they've been going on for years. Some of these programs are 10 or 13 years old. They're not new.
Thank you very much. Thank you, Madam Chair.
Thank you, Delegate. Colleagues, we have 3 more colleagues in the question queue. We will accommodate all 3, but I'm going to close off the queue to additional people raising their hands. So next is Delegate Acevero, followed by Delegate Crutchfield, and then lastly, Delegate Ziegler.
Thank you very much, Madam Chair. I had 3 questions, but one of them were answered. Appreciate Delegate Merrick North's contribution. So, but I'll just pivot to my next question about State's Attorney McCarthy. Your office, will you commission a study about the disparities, particularly in your office, around prosecutions? Haven't heard much about that report since. Can you update us on where things are and where your office is rather on, implementing recommendations from that report, if any, particularly around sentencing and prosecution, if you can speak to those too. And then I'll ask my last question, because I know I have some of my colleagues that also have questions. And my next question is, we talk a lot about engagement with high schools and young people and all of these programs, which I think are great. How much engagement is done with our young people, juveniles, kids, high schools, MCPS, specifically around their rights and interactions with law enforcement, what they should know, so that our young people aren't also being taken advantage of in those kinds of circumstances. So you spoke a lot about, that engagement, and I appreciate the answer from Mr. Sims. But what is being done to educate our kids outside of the nonprofits that exist both here in Maryland and elsewhere? What is your office doing to educate our kids about their rights? So if you could speak to the disparity study and where your office is with that, and then also what your office is doing as far as educating our youth.
Let me begin by saying the answer to the disparity study, first of all, is up on our website, and it's available for everybody to look at. I think the report is about 52 pages long. For those who are not aware of it, I became the first state's attorney's office in the state where I commissioned and allowed an outside agency. It was the MacArthur Foundation was involved. Amazon was involved funding it. It did not cost the taxpayers of Montgomery County anything. It was about a 2-year study. There are dozens of charts and graphs about the process in there. Quite candidly, I believe that they did not find any racial disparity in the way in which prosecution took
they're
place.
still talking to John, and they
I
still have multiple questions to go.
Hey,
Oh,
Rich,
I'm sorry. If Ralph can please mute other folks. Thank you.
okay. I think that the study, if you look at it, did not find any racial disparity in the way cases were handled according to race or ethnicity in the office. I think that's the bottom line to what they found. They did not find what maybe the question suggests was present. One of the things that fundamentally changes the system in Maryland from most systems in the country when you're looking at criminal justice issues and numbers is that Maryland is a direct filing system. What does that mean? A police officer can make a charge, make arrest, and there is no screening by the prosecution ahead of time. We are not involved in the charging decision. They go to a commissioner, they fill out an affidavit. If the commissioner feels that there's probable cause that a crime is committed and a person named in the petition committed the crime, they're going to issue that charge. In most jurisdictions, because I am now involved in nationwide studies. I'm going back again. Look, Loyola University, University of Maryland, Bowie State University, we're all involved in putting this study together. The graduate study program at the University of Maryland was the key authors of this. Dr. Brian Johnson, who has been with multiple agencies and groups. I used a group called Progressive Prosecutors Initiative. They made recommendations. We are following through on those recommendations, but I think you're going to find that, like most states, the arrests have to be signed off on by a U.S. attorney or the local prosecutor before the arrest is allowed to take place. That's not the system we have. As a matter of fact, under the law in the state of Maryland, I think this is constitutionally protected. If you're over the age of 18, you can walk in to a commissioner's office, swear under the penalties of perjury that the guy next door stole your lawnmower, and the next thing you're going to know is if you swear under the penalty of perjury that that's true, that guy's now charged with a crime. No police, no prosecutor involvement. We get a couple of thousand of them a year, where the charging doesn't originate with my office. It almost never does, and it doesn't even originate with the police. So when you're doing analysis of these things, it's a much different thing. So when you look at the study, I think ultimately you have to say, what happens to the case once it gets to the state's attorney's office, which is the first time we ever have an ability to affect it. And I think quite candidly, I think you're going to find that the plea offers, the sentencings, and the disposition of the cases is equal across all racial lines once it gets to my office. And I don't think that there are any discrepancies in those areas that are accountable to the state's attorney's office.
Right.
I think that's what it says.
Mr. McCarthy?
State's Attorney McCarthy, really quickly. So I went to the website, I skimmed the report here, and while there were no disparities found in terms of prosecutions, there are disparities in terms of sentencing of Black and Latino defendants, particularly from your office. And so
no, that's not correct. That's not correct. They actually attributed that to the courts. They didn't attribute it to prosecution.
But do prosecutors not have like sentencing? You recommend sentencing, et cetera. You play a role.
Yeah, we play a role, and we are guidelines. We are primarily, there are Maryland sentencing guidelines, and there is a philosophy in this office. We look at the Maryland sentencing guidelines, and our plea offers, with a few exceptions, are always within the Maryland sentencing guidelines. We are a Maryland sentencing guidelines office by philosophy.
Okay, well, I won't beat that point, but prosecutors do play a role in sentencing.
I agree. That's right.
There's a disparity in sentencing. I find it difficult to understand how we can separate prosecutors from contributing to that sentencing when they are part of the sentencing process. But don't want to, if you could answer my last question about young people and what is being done to educate them about their rights, particularly the law that we just passed and interacting with law enforcement. I know there's a lot of engagement and educating about other things around truancy and violence, all important. What is being done to educate our young people about their rights?
Can I address that, Mr. McCarthy?
Yes, please.
So yes, Delegate Acevedo, we actually have a presentation that we've given. It's called, it's exactly called the thing you mentioned, Know Your Rights. This is a presentation geared toward young people, and we've given it last summer. We presented it in Wheaton to a group of young people, knowing your rights. What are your rights with regard to your right to remain silent? What are your rights with regard to your right to consent to search or not to consent to search? So we provide that. Next month, I'm scheduled to speak in Long Branch, down in Silver Spring, to the Teen Advisory Board at the Long Branch Library, group of young people, and I'm going to plan to talk to them about this very topic. So we have a presentation specifically geared toward youth, specifically called Know Your Rights. We've given that presentation. We plan to give it, and we're happy to help advise young people about their rights.
Good to hear. Thank you, Mr. Sims. Thank you, Madam Chair. And I hope that presentation includes what we recently did with the Child Interrogation Protection Act and the Miranda rights that we've effectively created for young people, etc. So I hope that presentation includes that so that folks are aware of updated information and laws that the state legislature have passed. Thank you, Madam Chair.
Thank you. Delegate Crutchfield.
Thank you, Madam Chair. Thank you so much, State's Attorney McCarthy, for being here. One of the things I noticed is that your discussion has really revolved around the Juvenile Justice Reform Act, which was passed in 2022 and, of course, enacted last year and I'm sorry, in 2022 as well, and has probably only been in place for about little over a year and a half. And as you know, there were numerous stakeholders in the Juvenile Justice Reform Council who actually worked diligently on this law for over 3 years with many hearings, etc., including the State's Attorneys Association. And so one of the things I guess I'm most concerned about is that a lot of the criticism for this is coming from some of those stakeholders, such as yourself. And what I'd like to understand from you is that most of your proposed legislation is dealing with additional interventions, prosecution of children by the state's attorney's office. And I want to just understand and know, have you actually talked to any of the other stakeholders that were on the Juvenile Justice Reform Council, such as the biggest stakeholder in this, which would be the Secretary of DJS, regarding any of your proposed legislation, and what has that feedback been?
We've read their reports. I've actually talked to Mr. Schiraldi a couple of times. I've also talked to representatives of the governor's office. I've talked to you most recently down in a legislative hearing. And one of the reasons that I'm here today, because I think we need to be more proactive. I think, quite candidly, and maybe where the ball got dropped is that we were not proactive enough. And I'm very, very thankful to Delegate Carr that very, very quickly gave me the opportunity to be here to talk to you today, because I think some of these issues are going to come up again in this session. I know they are. I know that there are bills that are being drafted, not to repeal, but to tweak some of the aspects of it, because we see some of the results. Like, I mean, the 6-month limitation. Did anybody know about the delays and the lack of space and the fact that we're, like, I don't know that we necessarily knew that as well as we now know it experientially as we look at this thing. I think there's some things that we are now experiencing, and the things that I'm bringing to your attention, quite candidly, I'm giving you Montgomery County numbers. Why? Because you're Montgomery County delegates. I think I could probably go almost anywhere in the state and get similar numbers from almost anyone who would make the same issues. When we had been talking to the chairman in the House and the chairman in the Senate about what some of our concerns are here, it is a pretty much uniform voice of the 24 states attorneys. This is not unique to me. And some of the issues, there are some things that maybe these are kind of consensus things that we've been talking about that I think are going to be in some of the bills you're going to see to amend it. But I think it's an experiential thing. And quite candidly, maybe we are a little bit, we should have raised some of these issues earlier. But now that we see what's happening and we see the rise in juvenile crime, again, out of the interest of public safety, let's take a look at it. I think maybe we have not communicated as well as we should have with all of the different agencies. That's why I'm doing this reach out. That's why I've already agreed to. I'm trying to meet with the Black Caucus to talk to the Black Caucus. I'm trying to talk to legislators. That's why we tried to have, you and I had a conversation about this. I'm trying to talk to anybody I can about what I think's happening in Montgomery County that's affecting public safety, and some steps, not the repeal of the act. The spirit of the act, I understand what is attempted to be achieved, but again, do it knowing what the consequence has been of some of the changes. Do it knowing what the numbers are. Do it knowing that there are not spots for these kids to get services. They don't have, you have twice as many kids being referred to treatment as you have spots. And they're not getting it. They're churning those kids in and out so quickly they cannot possibly be getting the kind of attention or treatment they need. And that's what we want to talk about. It's about treating kids. Some of these things are I think, are barriers to getting them the help they need, not assisting them to get the treatment they need.
So Mr. Carthy, with that in mind, I appreciate you being here, but again, all the information you've presented has been a lot of percentages. And as one of the other delegates mentioned earlier, we really need to see the numbers behind whatever the percentages are. Okay. Appreciate you presenting us with 2019 data and 2023 data. But again, we really want to get to the root cause of what you are seeing so that we understand and know, because we are, like you just mentioned, all here to absolutely be advocates for public safety. So thank you very much.
If I could, on that last point, what are we seeing? Because for technical violations on misdemeanors, what are we seeing? We're seeing kids blowing off probation because there's no teeth in keeping them to honor the conditions of probation. That's what we're seeing.
But what are those numbers? Show us the numbers. Show us what you have seen, okay? I appreciate that very much, but show us the data behind it.
Thank you.
Thank you.
And lastly, Delegate Ziegler.
Thank you, Madam Chair, and thank you very much for the presentation. I just wondered if you could say something about either from data or even just your personal sense of this, of what happens when especially the younger children are held in detention. Obviously, it gets the kid off the street. It's not stealing cars or whatever it is, but is there any sense that you have that we're able to deliver services to create anything positive out of that situation, or is that just sort of the start of a life of crime and being in prison?
I think may I say, I think that the quality of the programs, I think, is in question. The length of the programs is in question. I think, let me say this. I think detention does not necessarily mean lack of treatment. Does it not necessarily mean you're not actually making the long-term outcome for that child better? Again, maybe there's a fundamental, I think it is a treatment. If we had an inpatient drug treatment facility in the Maryland that we could send a child to, and they needed inpatient drug treatment that they couldn't otherwise afford because of the economic situation they were in, that would be a great thing. Some of this is about money. Some of it's about funding. Some of it's about programs. But the reality is, do we understand that we are not servicing the number of kids we have already? We're not servicing those kids. And a lot of this is a begging for having greater faith in the judiciary. But I think there's some great men and women that are your judges in this county. that were vetted and elected to be judges, and they're not being given the authority to put together programs necessarily for the kids they see. Carlotta, do you have a comment that you'd like to make? I wanted to say on this question at all.
I would just say that I think you mentioned younger in detention. And I have to be honest with you, detention is not done lightly. And I don't see a lot of younger in detention, if that's what you're looking for, like the really younger ones. And it is not really used as a punishment. It is used when it is necessary for the protection of that child or the community. And we are not seeing kids being detained continuously. That's not what we see, even with the judges and with the Department of Juvenile Services. It is done on a necessity basis. When you have a child that comes in who is high in court on fentanyl, who cannot stop, sending them home on a community detention is not going to benefit that child. You're not going to be able to get that child to detox. You're not going to be able to get that child to get off of those particular drugs by keeping them within the community. So what I can say is that we don't see as much detention as you may think. And the younger ones, there is a push to not detain them, to get what they need while they're in the community, to wrap around those services that particular child needs. Detention is typically a last resort. And that's honest. I mean, that's kind of what we see. But it's really fashioning the appropriate services to that particular child. And in some circumstances, regardless of what the offense is, right? Like if you have a child that's coming in on a very serious offense, but only maybe needs behavior modification or maybe needs something within the community that we can provide, we do that. If it is a minor offense, which we don't see a lot of, to be frank with you, but when we are getting these particular cases, it is, what does that child need? You know, if you have a child coming in who's being human trafficked, and they're coming in on a minor offense and you are trying to protect them from going back to the human trafficker, you have to be able to try to facilitate in the protection of that child. And so I think that that's kind of what we really look at. But for younger ones, honestly, detention is the absolute last resort because you are not wanting to remove that child from the community. The basis is to try to give those services, and our services are dwindling. I've been doing this for many, many, many years. And the amount of services that we provide in the community today or out of the community are so far and few between of what they used to be. I don't know if that helps what you were asking.
That's very helpful. Thank you. Yes, I appreciate that.
All right, I think we have come to the end of questions. State's Attorney McCarthy, thank you to you and your team for being here today and for such a long period of discussion. We very much appreciate the dialogue, and hopefully this is just continues the conversation and will not be the end of it. And I think with that, we will release you all and move on to our next agenda item.
Thank you. Thank you very much. If I could say that, and I appreciate your patience and I appreciate very much the great questions that everybody gave. Thank you.
Thank you. So our last agenda item for today is a continuation of our discussion on bus rapid transit, BRT, with the county, and Director Transportation Chris Conklin is here to continue. Colleagues, if you recall, there were 3 parts to the county's presentation last week. We ended up having to really rush through that last section, and so we're just going to pick up there on transportation funding strategy. I do want to acknowledge that the county executive was here earlier in the meeting, but because of our kind of fluid agenda today, he had to leave. But I do believe Director Conklin and perhaps others from the county will be presenting, and I will turn it over to them.
Well, good morning, Madam Chair. Thank you for the opportunity to continue the presentation. This Chief Administrative Officer, Rich Madaleno, is with us in the executive's place, and we'll go through the last section of the presentation that we didn't cover in detail last week. So, Rich, it's all yours.
Thank you very much, Madam Chair. I can tell you I'm looking straight out at Rockville and the streets are being plowed as we talk. So that your municipal government is hard at work. And of course, our county staff are all over the county cleaning up the streets, and the county government is open today, but with liberal leave. So not all the facilities. So wanted to thank you for coming back to this topic and go as quickly as possible because, Madam Chair, are you going to say we've got 10 minutes to talk before you got to go to the floor at 11? I'm trying to
Well,
think
you are in luck. We are a little bit of a captive audience today because the floor session is pro forma. So with the exception of Majority Leader Moon, the rest of us we don't have to be at floor. I think most people have gone home. So if we need to go a little past 11 today, that would be okay. So I think we definitely have till 11. And if we need to go a little after, that's fine.
All right. And it's, always exciting for me to put those words together. Majority Leader Moon. That's one of the things that we've been talking about, and that I'm sure you've heard the county executive over the last several years talk about is how do we remain competitive with Northern Virginia? And I'm sorry if I'm going to go over some stuff that was discussed last week, but one of the things that we've been trying to do is educate people around our community and around the state about how at least Northern Virginia has moved forward with identifying the funds in order to do the infrastructure that's needed. And about a decade ago, 12 years ago, Virginia embarked on a change to the way that they did funding for transportation, and especially in Northern Virginia. And the quick shorthand of it is the state of Virginia created a transportation trust fund just for Northern Virginia. And it creates hundreds of millions of dollars in revenue every year that is then used to match other state dollars, federal dollars, to build the infrastructure that has allowed Virginia in some ways to move forward with economic growth and job growth compared to suburban Maryland and Montgomery County in particular. So one of the key pillars of this was the authorization for the Northern Virginia counties to have a 12.5-cent property tax on commercial properties, each jurisdiction-wide, dedicated solely to transportation. So Arlington County, Fairfax County, Prince William County charge a 12.5-cent additional property tax. That money is just reserved for transportation improvements. And you can see in both, these are screenshots from the Fairfax County budget and the Arlington County budget that explains the 12.5-cent tax. In fact, when Virginia initially did it, they gave their counties the authority to go up to 25 cents. All the Northern Virginia's counties went to 12.5 cents. And then the General Assembly just said, all right, we're gonna cap it at 12.5 cents. So you can see, in addition to the overall property tax rate for Fairfax County, which is almost $1.10, all commercial properties pay an additional 12.5 cents. Chris, if you can go to the next chart. Because I don't know who's running the PowerPoint. So I think so you can see what this has meant over the last over just 8 years within Northern Virginia, because their tax policy in Virginia says that they get, of the 6% sales tax in Northern Virginia, 0.7 cents goes just to transportation, 1 cent goes to the county governments. But just when you look at the 0.7 cents, when you look at they have a recordation tax in Northern Virginia that's dedicated just to transportation, and a 2% hotel tax dedicated just to transportation, that they've been able to raise locally $3.3 billion for transportation. And you can see where it's gone, with Fairfax County being obviously the big big driver of those dollars. If you want to go to the next chart. So again, some differences between Northern Virginia and Maryland, especially on a day like today. All roads in Virginia are state roads. Fairfax County maintains only 10 miles of roads. So, you know, I think the Chevy Chase Village actually maintains more roads than Fairfax County does. So it is a totally different model. The state is responsible for maintaining all the roads. Local funds are used just for capital improvements. Again, to reiterate, tolls on the Dulles Toll Road have been, the Dulles Toll Road was given to the Metropolitan Washington Airport Authority. Tolls on the toll road support not only the operation of the maintenance of the toll road, but the construction of the Silver Line. They created a project review process. For those of you who were in and around the General Assembly during the term, 2014 to 2018, the General Assembly did something similar to this, that the Hogan administration, I think we had to override a veto on it, but to try to prioritize projects, there is an effort to objectively prioritize all the projects in Northern Virginia and then to move forward with the top scales. The point that the county executive tries to make over and over is the system that they've come up with Virginia, and we don't have to mimic the entire system, the tax structure, but the key is it provides a degree of stability and a dedicated revenue so that you can actually bond against them for large projects. And that's fundamentally our problem. We have in Montgomery County, we have a series of impact taxes. So you want to build a new office building in downtown Bethesda, you get a big assessment and a charge for that. And what we have heard repeatedly from developers is that additional tax, that upfront tax, then you have to finance, add to the overall project costs, and that adds to the capital stack of the project. In Northern Virginia, because you are not doing those impact taxes, but you're having that additional commercial tax, you are generating the revenues on an ongoing basis from the project, from all your commercial properties, that has a degree of stability that allows you to bond against it and build the large projects, which have really distinguished Northern Virginia from Montgomery County over the last 12 years. And that with our impact taxes, you get a bunch of money all at once, but you only have it as cash to spend, and there's no guarantee that what you spend it on is going to be anywhere close to where the building has been located. So think of it as a comparison between you might get a one-time inheritance from an aunt or uncle, and you have that to necessarily buy a new car, but that's a one-time purchase. You get a new job, you have that income, you use that income to then qualify for a mortgage, you buy a new house, and that buying that new house is a far better investment. And that's the same thing for governments. We have no idea. 1 year income taxes could be enormous, the next year it could be zero. You cannot use that to bond against it, unlike our property taxes, where you know how much is going to come in, you have a high degree of confidence, you only borrow against so much of it, and then you can build large things with it. And that's where, under our system, because we have to build roads, transit, schools, libraries, everything out of the same pot of money, we are unable to pursue large projects that would allow us to remain economically competitive with Northern Virginia. And if we don't find, in combination with the state, a way to move forward with our transportation funding, and the governor has been very clear about that too, we will not be able to compete with Northern Virginia, with other parts of the country, because we simply do not have the ability to keep up with the current structure that we have. Now, that's why the county executive has said he wants the state to move forward in a similar manner. Why the Maryland Association of Counties is moving forward with a bill that would allow, very much in line with, Madam Chair, your efforts over the last several years, to say you could have property taxes that are differentiated from a rate standpoint, because right now in Maryland, for the counties have to have a single rate on all classes of properties. Municipalities don't have to do that, but county governments have to have that single rate against all classes of properties. And so what the executive has been saying is we need some additional tools that will allow us to generate revenues, will allow us to be a better partner with the state and the federal government to do some of the very large projects like bus rapid transit, which is the policy the county has now had for more than a decade as its single largest view of growing mass transit, which of course accomplishes many of our goals. What I like to summarize as the 4 C's, our goals around congestion, carbon, cost, and competitiveness, because it's the only way. I mean, we obviously have to move forward with roads, but we have to address congestion. We have to address climate change through reducing carbon emissions. We have to figure out a way to make this cost effective and affordable, and the improvements are the most cost efficient. And of course, it's all in the end about us remaining competitive. So in addition to the broad-based programs that Northern Virginia has initiated, they have some special taxing districts. Virginia has been aggressive at like phase 1, phase 2 of the Dulles Toll Road. So when you think about that, in Fairfax County and Tysons, you have properties that have a $1.10 general assessment, a 12.5-cent commercial property tax assessment, an additional 18-cent if you're in the phase 2, 18 cents property tax for being in that special taxing district. So $1.40 for businesses for commercial projects in Northern Virginia, whereas that same office building sitting in Bethesda or outside of in Silver Spring, in Wheaton, would all be at $1.04. So these investments, these taxes are higher in Virginia, but they've bought infrastructure, and that infrastructure has allowed more development to occur. And that virtuous cycle is what we want to see in Montgomery County as opposed to what we have now. I can keep rolling on, but I see Chairman Corman has his hand up. So just to close, the big ticket item, $7.1 billion of economic impact for this tax policy in Virginia. They've been able to raise more than $6 billion in funds for infrastructure improvements in Northern Virginia between the local taxes and the state and federal funds they've been able to get. And that obviously has an impact on their ability to continue to grow and attract private investment into their community. And I really appreciate you giving me the last second. I got a text message a few minutes ago saying the county executive is at the big groundbreaking in Burtonsville, ribbon cutting in Burtonsville for the Sprouts grocery store, the anchor to the Burtonsville, the new Burtonsville shopping center. I want to very much thank the District 14 legislators, several of whom are on the call. Several of them are no longer in office, but like Delegate Lukey, but who worked very hard to ensure that there was state support for this project to move forward. It's very exciting for that whole corridor to see the growth and the great partnership between the county government and the people, the legislators from District 14 and District 20.
Thank you. And I think we can open it up for questions. Delegate Corman.
Thank you, Madam Chair. So, Rich, you foresaw this problem in 2010 and passed legislation that actually allowed for something like this. Is the problem the classes of property, that you can't use the 2010 bill to create a special taxing district because the classes of property within that taxing district have to all be the same level, and you want to differentiate commercial from residential or what have you? Is that the issue?
Correct.
But I'm sorry, but in North Bethesda, the county did implement your bill and just created sort of a gerrymandered special taxing district. Is that how they did that there?
They did it, so what the law I got passed did for transportation improvement districts is it also specified that the revenue that was coming in through those districts was not counted against the county charter limit, because that was also one of the problems that we had in Montgomery County was all the funds that were raised through these transportation improvement districts were getting caught up in the county charter limit. So you couldn't raise the funds without making an equal reduction somewhere else, which isn't what anyone wanted out of, in my humble opinion. And in the county charter. So
Sure, no, but you
now
already
it fixed
successfully
the
did that.
charter, but
So,
yes,
yeah,
in the
sorry, so I'm
White
trying
Flint
to
special tax.
understand what's the problem you're trying to solve now that you didn't solve in 2010? And is it the problem of gerrymandered special taxing districts because of the classes of property?
So if you just look at the White Flint Special Taxing District as an example, the county had to move forward with, again, the Swiss cheese approach to, this property, and not the entire zone. And then you only have a small number of properties in order to try to do a limited number of projects within a small zone of the county. What Northern Virginia did is move forward with that 12.5 cent. I'm using that as an example, the 12.5 cent countywide transportation tax that is dedicated to infrastructure. So that's bringing like $60 million a year into Fairfax County. And then they have the smaller special taxing districts that are for very specific projects, like the Silver Line, phase 1, phase 2, the reconstruction of the Route 28 corridor. So it's a simpler way to move forward than, if we wanted to create right now a special taxing district for bus rapid transit along Route 355, let's say from Friendship Heights to Clarksburg, you can imagine the difficulty of trying to figure out and identify in the law every different commercial property as opposed to residential property going all the way up the corridor, as opposed to just saying, here's the corridor, and then we're going to assess the property tax on these classes of properties within the corridor who are going to be the ones that benefit most from, in this case, I'm using bus rapid transit on 355 as an example.
Okay, I mean, as you said, this has been the policy of the county for like 10 years to do BRT. So I can't imagine making a map of 355 is actually that difficult, but okay. Could I ask one follow-up, Delegate Pluck, Madam Chair?
Of course.
Great. So, Rich, in Northern Virginia, they have this authority and the money gets split. Some goes directly to the counties. I think it's called local distribution. And then the rest is allocated to this authority. It might be 70-30 or something like that. I don't remember the quite the percentage. When I hear the county executive talk about this, which I've heard many, many times now, I never sort of hear about that element. Is his vision for this that all the money flows to the county? We're just giving the county the authority, or does he envision sort of the regional authority issue? What's his kind of vision there?
So to be clear, all of the property tax revenues that are generated by the special taxing districts, the commercial property tax in Northern Virginia, stays with the individual counties. So that is not split or shared with anybody else. That 12.5 cent tax rate for Fairfax County stays solely with Fairfax County. The other piece of the transportation plan in Northern Virginia, which I tried to go over very quickly, the 0.7% of the sales tax rate, the recordation tax, which they call a grantor's tax, and the hotel tax, that fund is split 70% to regional projects, 30% to the local government where those revenues were earned. So again, that sales tax component is split 70-30. The property tax component stays solely with each one of the local governments. So there is no, so when I say, the county executive wants similar authority for Montgomery County to have a countywide commercial property tax, that, just like Northern Virginia, that would stay with the county government solely for transportation improvements. Those are dedicated only to transportation improvements. If you all wanted to work, and I'm sure the executive would be happy to talk about different ways that we could work on regional funding models and move forward in a similar model, yes, then that funding split makes sense. But again, the property tax revenue that's generated in Northern Virginia stays each solely with the individual county.
Delegate Solomon.
Thanks, Madam Chair. Rich, thanks for being here as always. I just had two quick questions. So the first question, and I feel like I'm just refreshing my memory in the conversations we've had on this before. This would be, if we were to give you this authority, this would mean the county would do away with the impact tax, correct?
That is the goal that the county executive has said over and over, that let's not do these upfront impact taxes for infrastructure if we have the ability to raise money over here through a set tax rate.
Okay, and then so the follow-up question is, I mean, and this is a little bit harder to do, but has there been discussion, again, if we were to give you this authority, so obviously if you built a building 2 years ago, you would have paid the impact tax. If you're in the planning for a building, theoretically, you wouldn't be paying the impact tax if the building was going to be completed in 2 years and you implement this in a year. Is there a conversation around for buildings that have already paid the impact tax, phasing it in so that, you know, everybody isn't immediately levied with, again, if you have a brand new building, you're paying the same percentage as somebody who's built a building 5 years ago, paid the impact tax. Is there a thought about doing it that way?
I think there would be. I don't want to, you know, in this case, Delegate Solomon, it's not me making this final decision. So I don't want to say, sure, that I think that makes complete sense. I think we would try to go down that path from a fairness standpoint. But I can't, knowing the executive, I think you would be open to it. I would assume members of the county council would also be open to that sort of approach.
Okay, that's what I figured. Thank you, Rich.
Yeah.
Thank you, Madam Chair.
Thank you. Any other questions, colleagues? All right, seeing none, I'm glad we were able to get through the presentation and give sufficient time for questions. Thank you both for rejoining us here this week. We very much appreciate that. Colleagues.
And thank you. And I'm sorry this has been disjointed between the 2 weeks. We're always happy to come in, any one of you, to come in and sit down and explain it in more detail, answer your questions. I think no one knows more than Delegate Polakovich-Carr that the county executive is happy to talk with you about this issue.
Thank you. Thank you again. And colleagues, before we adjourn, I neglected to mention when we were voting that Delegate Wu is excused today for a medical appointment. And I did just want to get Delegate Kaiser on the record. She was here when we were voting, but was having some technical issues. And so Delegate Kaiser, it's my understanding you wanted to vote affirmatively for the 2 amendments and for both bills that we took up earlier. Is that correct?
Yes, I thought I was on the screen for most of them, but I did have to switch between my laptop and phone at some point. So I may have missed. So I thought I might have missed something. So thank you, Madam Chair.
Yes. Okay. Thank you. And with that, colleagues, we are adjourned today. Thank you for staying for an extra 3 minutes.